So if things don't come off feeling organized, it's Courtney's fault. It's not mine. So welcome, and for those of you who are here for CLE credit, wave your hand, Christine. Over by Christine, there's a sign-up sheet if you want to sign in for CLE credit. And feel free, a number of you have already started eating lunch, which is great. But this is one of the Vermont Law School environmental program hot topics lectures, which is terrific. We have this opportunity here in this community to have amazing people from around the country, from around the world, come to speak to us and describe some of their work and thinking. And I'm so pleased to be able to introduce my friend and former colleague, Tseming, who is a former professor here at Vermont Law School, where he taught international environmental law and comparative law, and also was responsible really for launching our U.S.-Asia Partnership for Environmental Law. And for those of you who don't know, that's been an amazing program here that's been very engaged, primarily in China, but across Southeast Asia. And we owe that program to Tseming and all of his work. But he's currently at the University of Santa Clara in California, where he teaches environmental law, among other things. He is a former deputy general counsel at EPA, or he played an important role under the Obama administration, and has so many more credentials. I won't waste all your time going through them, but I'm so pleased to be able to turn it over to Tseming. Thank you so much.
All right. Thank you so much for that kind introduction, David. I'm really delighted to be back here, and let me just start off by saying just thank you, David, to the ELC, to Courtney, to Megan, to Tracy, to Dean McHenry, and really the entire Vermont Law School community. It's been really a wonderful opportunity to be back here. I was just telling David, I went on my morning run just this morning. I'm situated in a house in Tunbridge, and I was able to go and be on the road for half an hour without ever encountering a car, which is, of course, totally different. I came back just a few days ago, actually, from a teaching stint in Singapore, and not only do they drive on the wrong side of the road, so you really have to be super careful in crossing the streets, but it just is super busy. So this has been really just a pleasure to be here. I will also say, it's been really fun to be back. A lot of things are the same. Everybody looks equally young as I remember them, including Kinvin and David, of course. And I'm really pleased to be now in the Stephanie Wilbank's classroom. It was named just 012 before. But I will also say that the years have also not left me untouched. And now I really need reading glasses in order to read my notes. I had extra large print just as. All right. Let me actually maybe start off just by putting a little bit of context to my talk here before I launch into what I've, let me go back. What I framed here entitled as the globalization of environmental law, or alternatively, what I'm really now sort of focusing, it's really just an alternative perspective here, the emergence of global environmental norms. I'm going to provide some background to this topic. This is something that I've worked on for many years, but most recently, there is an article that is going to come out probably sometime in the spring or so, of some empirical research that I've done that I'll talk a little bit about. Really, the issue of environmental impact assessment and the duty to do an environmental impact assessments as a global legal principle, as a general principle of international law. And if that doesn't mean anything, I'll try to explain to you why that I think is at least to me, having spent all these years on this, is actually a really important issue, and I think has significant ramification for how we think about environmental law, environmental norms as they're evolving internationally and in other countries. As David indicated, when I was here, I taught international environmental law. I also spent a lot of time working on China-related issues, and it's really through that context, actually, that I really spent, or started to spend all this time on thinking about how environmental regulatory systems are evolving and working in other countries. and so I say this here really in order to put one additional sort of frame or lens on what I do. You know, a lot of scholars work on more normative issues. What I mean is normative issues in terms of the question of what people should do, what the law should say, and what, you know, as a normative matter, we as a society and what companies should do. And it's really clearly very important. It's really sort of appealing to the government and to industry and to individuals about the things that they're doing wrong and what the correct thing to do is. I will say that I have done less of that work over the years, in part not because it's not important, but because I found it to be frustrating in the sense that on many environmental issues, we all know what actually the right thing to do is. And part of the challenge actually is to figure out how to get people to actually behave in the way, how to get companies to behave in the way that actually accomplishes so that the better environmental outcomes. And so I spent a lot of time over the years thinking about the institutions and structures, really sort of what, especially I think it's been really a wonderful analogy, the architecture of the law. This has been something that in the cyber law context, the law governing the internet, technology, people spend a lot of time thinking about, because the technology imposes constraints on what people can do and therefore also directs the operation of norms. And so what I'm interested in has been really focused on the structure of treaties, the institutions in international environmental law, and also, of course, at the national level. So this is just a frame and sort of how I approach the issues here. All right, so to start here, this is what I want to sort of talk about here. So these three broad topics. The first one, patterns of globalization, it's really just just sort of setting the stage, the background. Most of this is stuff, or all of this is really stuff that I think everybody in the audience who has not been living on a rock is familiar with, but I think it's useful just to put a little bit of context to what I'm going to get to. Then I'll talk a little bit about what drives globalization of environmental law. This was part of an article that Bob Percival, who teaches at the University of Maryland Law School, and I think is also in the summer faculty here. Bob and I did a paper on an article on almost 10 years ago, actually, really observing sort of how environmental law has become much more global, and you know, what we thought and what we think sort of are the drivers of that, not just in terms of the factual phenomena, but sort of, you know, trying to categorize or put sort of a framework for understanding these kinds of trends. And the last one is probably what I want to spend a little bit more time on, which is sort of the implications. How do we think about this phenomena of globalization of environmental law? And this sort of directly relates to this more recent article that that's coming out, focused on this issue of environmental impact assessment, sort of as this global norm, and what that specifically means, both with respect to environmental law generally. Again, that may be less novel, but more importantly, I think what it means with respect to public international law and the idea of the evolution of international law generally. So let me just start with this. This is really just a slide here just to, you know, just to point out globalization comes in many forms. You know, we've seen it in terms of transportation, international trade. Maybe the most, I've found sort of the most salient has really been sort of the World Wide Web, right? Just how we are now able to interact, to get goods, to get information, just as easily from the other side of the world as, you know, from just, you know, the other side of campus with the World Wide Web. The other side, of course, has also been the global trade in waste, movement of pollution, and really so embodying this broader adage, maxim that environmentalists, and I think really everybody is now quite familiar with it, which is, you know, everything is connected to everything else. Sort of fairly obvious. It's led to sort of this broader, together with sort of the recognition of the impact of humanity on the globe, This is a slide that I think Michael Dworkin always loves to show about the energy impact. I thought I would appropriate it. I also wanted to, I had thought about trying to just have us a slide of global climate change. I couldn't find one really that sort of embodied, I think, what I wanted to show, which is the global nature of all this. But it just illustrates how much, I think, humanity has transformed our planet and how much I think both globalization and sort of the connection of society and the environment have changed both our perspectives and I think the issues that we deal with. I think not as obvious as the idea that so everything is connected to each other and that globalization has had these kinds of impacts on the environment is the issue of globalization of law. Globalization of law, I think, has become more obvious in recent years. In the environmental context, we see this especially with the various rule of law initiatives. This is actually somewhat dated already. The ABA Sealy initiative, this is a law in Eastern Europe trying to help Eastern European countries in the wake of the fall of the Soviet Union redevelop their legal system, and a significant part of that was developing environmental law. The Agency for International Development, this is of course squarely what the China partnership or the US-Asia partnership here at Vermont Law School has worked on and what I worked on. It's also a lot of what, so law reform, environmental capacity building, was actually a substantial part of my portfolio when I was Deputy General Counsel at EPA. So went from doing this kind of work at Vermont Law School to what EPA and other government agencies have been doing. What this illustrates is that you see environmental law really all across the world. And it's the same kind of process, effort, initiatives that the World Bank and other multilateral development banks have done, engaged in, and more recently over the last decade or two, increasingly even UNEP and other NGOs. We also see, I think in terms of globalization, not just the phenomenon of more environmental law, but also much more interaction between environmental lawyers and judges and really institutions, the emergence of these transnational networks. And you know, some of this may not be so commonly known, but the IUCN, the World Conservation Union, for example, has an environmental law committee that sort of draws together a lot of environmental lawyers and academics from across the world. There's e-law. If you're not familiar with this, this is this international network of public interest environmental lawyers at the University of Oregon Law School. Initially started there. The IUCN Academy focused on environmental law academics. Really what I'm trying to point out here is that we see environmental law, environmental lawyers, and judges engaged in that all across the world. Now, if you think that that is sort of obvious, all I would say is I think this was not at all obvious when I started practicing environmental law. I remember when I was still practicing at the Justice Department Environment Division in the 1990s, I was invited to this presentation. You know, at that time, you know, I'm a US trained lawyer. I'm Chinese American, but really I'm an American lawyer. I went to law school here in the United States and learned American law. And I was invited to this presentation by these Chinese government officials from what was then the State Environmental Protection Administration, SEPA. This is in 1996 or 97. And what struck me about that is that there was really almost no relationship. I mean, there was real difficulty really understanding what the system was in China, even though the presentation sort of struck a lot of familiar, brought up a lot of familiar concepts. There was no way for myself or really any of my colleagues, and including the people at EPA, to really provide and put into a common framework of understanding of what it was that these colleagues from China were engaged in, actually, even though they had similar system. And in large part was this really lack of understanding of how Chinese law and how the Chinese regulatory system worked at the time. So different now, actually, when we look at, of course, what those interactions are now between government agencies here in the US and agencies in China and elsewhere. The other sort of significant process of globalization with regard to environmental law, apart from these active efforts of building connections, providing technical assistance, engaging in law reform, has been the growth of multilateral environmental agreements, right? This is sort of what I teach primarily in my international environmental law course. The proliferation of international environmental treaties, the best known probably really being the United Nations Framework Convention on Climate Change, but a series of other treaties that have been concluded since then, such as the Kyoto Protocol and most recently the Paris Agreement. But they're really only just a couple of a whole slew of environmental treaties that have come into being over the last 2-3 decades. And I just want to show something here that I find really remarkable. This is just a listing here of membership in those treaties. Of some of the major environmental agreements, starting with CITES, which was adopted in 1972. You see here now it has 183 member states. The entire United Nations membership is 193 countries. The Vienna Convention on the Protection of the Ozone Layer and the Montreal Protocol on ozone-depleting substances were the first international treaties that obtained essentially universal membership. Universal membership meaning that every state, every member of the United Nations was a party to these agreements. You notice that the number is actually greater than the UN member set because it includes some states that have observer status. And this +1 here, this is a very common one. This embodies or signifies the European Union. The European Union is not an actual state, but because of the relationship of the European Union to its member state, it actually has to be part of these international agreements. They act almost as a separate state because they have independent capacity and competence to act on the subject matters that are embodied within these treaties. But you see here, a lot of these treaties have a very large number, very high number of member states. And it means really that these treaties have significantly contributed to the spread of environmental regulatory concepts by virtue of states being parties to these agreements and having to comply with the commitments that they've entered into as a result. I'll come back to this. This is significant, just especially in terms of the sort of the spread of environmental law norms and concepts. Now, just as I said just a minute ago, maybe at this point in time, the spread of environmental law across the globe, might not seem as remarkable as I find it. Many might not find it so remarkable. And what I would remind those who think of this as being unremarkable is I think this is sort of in parts of the sort of looking at the growth of environmental law in hindsight. And maybe as a reminder that the nature of law is actually very, very local. In large part, this is something very practical that all law school graduates are very aware of. Once you graduate and you take the bar, you're only licensed to practice in one jurisdiction. Right? In a jurisdiction here in Vermont, or where I am at in California, just in California, you're not only not permitted, but you really should be very wary of attempting to practice law in a jurisdiction outside of where you're admitted to, simply because the doctrines, the rules, the process all differ significantly. And I point that out as a way of just noting that the idea that somehow environmental law concepts are global, I think to me still is rather surprising, because we start out with the premise that law is really a very local concept and an idea. The reality, of course, I think part of what we see now is that, and what globalization of environmental law illustrates, is that there are a lot of similarities, in fact, in the concepts and approaches of various jurisdictions and systems to environmental issues. And that comes really to the second part here of what I wanted to point out, which is why we see that. Why, in fact, do we see all these similarities across the world in terms of environmental law concepts and doctrines and regulatory mechanisms and approaches? And in this paper that Bob and I did some years ago, we point to sort of three sort of sets of trends, sort of mechanisms. One is transplantation, the second would be convergence, and the third would be sort of harmonization, integration. Let me point out here that these concepts, these terms here that we described here are not really intended to be, they really are just ways for us to capture, I think, broad categories of processes, and that they clearly overlap with each other. But I think they're useful in understanding sort of how various processes across the world are operating to generate sort of this, this phenomena, this what we observe as a similar regulatory system, mechanisms, concepts, doctrines in jurisdictions as diverse, as China or in parts of Africa here compared to the United States or Western Europe. And so the first one here of this transplantation is really just what that term here means, which is simply taking one regulatory concept and transplanting and moving it somewhere else. This has sort of been the bread and butter of what rule of law initiatives, capacity building programs like the US-China partnership and USAID and the World Bank and UNEP and others have been engaged in. That is simply sharing with developing countries, jurisdictions that are engaged in law reform, and sharing with them sort of what's worked in other countries and encouraging them to adopt those successful mechanisms. One of the most successful that I will come back to in just a few minutes has been environmental impact assessment. Our environmental assessment process under the National Environmental Policy Act of 1969, which at this point essentially has spread across the world. I think it has some significant implications. I'll come back to that in just a minute. The other one is convergence, just this phenomenon of similar outside pressures, regulatory pressures, leading sort of to similar design environmental frameworks or regulatory mechanisms. Part of where we see this is with how countries are implementing environmental treaties, for example. There are only so many ways of reducing carbon emissions, for example, and to the extent that they are useful, countries simply adopt them and in order to come to the same outcome. And the last one is harmonization integration, both what we try to describe sort of as horizontal and vertical efforts to harmonize and sort of disparate approaches, simply because there are benefits to international trade, to how countries are able to interact. Again, a lot of this is linked to international treaties, but not all. There's quite a bit of operation of voluntary standards, for example, the ISO, the International Standards Organization, the Codex Alimentarius. This is a international standard with regard to health and safety or food safety, and other organizations like that. A lot of voluntary work that is being done. So that's sort of what Bob and I had described as sort of what's driving a lot of this phenomenon. Now, the specific item that I've been working on for most recently has been environmental impact assessment. Right? It's a well-known regulatory mechanism first emerged out of the National Environmental Policy Act of 1969. It's been amazingly successful. It essentially has spread across the world. These are just a couple of examples here of Mexico adopting it, and in 2003, formally, there are previous versions of this, but this is sort of the legislation in China that sort of focused specifically on this. At this point, and this little chart here, I have to say, has taken me way too much time to generate, but there's just a lot of empirical work that went into this. In some part, this is actually not even quite finished, but this is sort of the paper that's coming out that essentially documents and describes where in the world environmental impact assessment has been incorporated into the environmental regulatory system, where it essentially has become a duty in those environmental legal systems. What you see here is that at this point, environmental impact assessment and the requirement that you engage in impact assessment before you start some sort of significant project that might have these adverse consequences has been included in almost every nation. There are few that haven't, or where my research and together with my RAs, we weren't able to quite fully identify it. This is really was a real challenge because of language and simple access issues. But here's a sort of graphical representation here. What you see is that except for these few countries in Africa and South America, and then there are a couple of smaller ones. Singapore, for example, is a country that does not have environmental impact assessment statute. Virtually every country in the world has adopted environmental impact assessment as a requirement before somebody builds a project or engages in action that has a significant environmental impact. And that's actually remarkable, I think, given that this development has not been driven by any international treaty. Right? This is purely the result of environmental lawyers, of multilateral development banks, of foreign aid agencies proposing, suggesting to countries that this is a good mechanism, and countries and legislators, government officials, adopting this mechanism as oftentimes really as their very first and most basic of the environmental regulatory mechanisms. So this is sort of one illustration of how, a specific illustration how environmental law concepts have spread across the world. So what does this really mean here specifically? So to see that something like environmental impact assessment is now a requirement all across the jurisdiction, almost all of the countries in the world. And I think illustrative of how other regulatory concepts have spread. What does that sort of mean? And there are really two sets of implications that I'll address here. One is on environmental law itself, right? So part of what this means is that acceptance, I think, of EIA is sort of just a simple recognition that this is a good practice, right? It's a best practice, a good practice. It's a good idea, like if, to the extent that you're familiar with NEPA, of course, is, what it does is it simply forces the development of information, and it's designed to make the decision-making process better, right? Give decision-makers information about potential impacts that then should improve the decision-making process. And, who can say, how can you argue about more information and better decision-making process? I mean, that's sort of the underlying sort of appeal of NEPA. And I think in some ways that is sort of a demonstration of how the power of something that is a good idea can spread across the world. It also demonstrates, I think, sort of on the other end, acceptance of this as something that every system should be doing, right? I mean, this is simple, a description of somebody looking across the world, seeing that government officials accept this as a duty, that regulatory systems, that legislators believe that this should be required. And so we might describe this, therefore, as a quote-unquote global environmental norm, right? Just from an environmental perspective, that this is something that environmentalists think and legislators think government officials, project proponents should simply be doing before they start. Another sort of implication of this is that these processes suggest something about where developing countries, systems that are trying to improve or reform their regulatory systems should be looking for ideas, right? And this is, again, not terribly deep, and you look to where successful mechanisms have been created and you adopt them, and this is really just, in some ways, a reaffirmation that this is a good idea. These are processes that can pay off. To me, I think this last one, I think, is actually really useful. The emergence of global norms on the environment, I think, holds some opportunities for environmental lawyers and the graduates of a place like Vermont Law School, in that what you learn about environmental law in a place like Vermont Law School is not only useful in the United States or in this particular jurisdiction, but actually may allow you and probably will enable you to practice some form of environmental law really almost all over the world. And what we see actually is the emergence, I think, of a practice of international environmental law in places, not just in international organizations or sort of international law-based organizations like the State Department or some practice before the International Court of Justice, but all of the multilateral development banks, tons of consulting firms that do rule of law work, and even sort of just in a private practice, advising companies about the requirements that they may face in other countries with regard to regulation and permitting and the like. Very similar approaches because of sort of these trends that we observe. Now, there's another set of implications that I think that I've sort of focused on more with this paper, and that is less obvious, I think. And it's a set of issues that I've, I wouldn't say struggled with, but certainly has been sort of on my mind for a number of years. And that is, what does this mean actually for international law, public international law, international lawyers, international law academics? The first implication, I think, I term this sort of as filling out international environmental law. What do I mean with that? Looking at the globalization of environmental law norms, I think helps us understand better how international environmental law, international environmental treaties fit with the broader trend of the evolution of law, and especially environmental law. Traditionally, international environmental law really was a field that was primarily occupied by the international law academics. If you look at some of the early books, there were assertions that international environmental issues were simply, legal issues were simply the application of general concepts and principles of international law to the environment. There was nothing special about environmental problems. If you knew international law, you could solve all this international, or you could provide sufficient legal counsel on these international environmental issues. And I think I have sort of strong feelings in that is simply incorrect. That really doesn't capture, I think, what environmental lawyers generally have come to appreciate, that there really is something different about the application of the relationship, the role of the environment with regard to, the role of the law with regard to the environment, that it is not only governing the interaction between people, but also providing guidance on, and really governing the relationship of humanity with the inanimate world, with the environment generally. And what it suggests here is that there's a relationship between the developments that we see at the national level with regard to environmental norms. The role of the rapid development of environmental law all across the world has had a significant impact and effect on the evolution of international environmental treaties. I think what we see with regard to those environmental treaties, the number of them, the commitment to them at this point in time has to be directly related to the change in awareness and consciousness at the national and levels below with regard to the environment, providing impetus to those international negotiations. And maybe specific, this is probably something, and this is not an issue that would be well known, but there's this question in international environmental law of soft international law, right? This is a concept maybe some of you have heard, the idea that there's quite a bit of law out there that is not quote unquote hard law, that's not binding. And part of this question, you know, that a number of academics, international environmental law scholars have explored is, what is the role of that? What is the meaning of that? And part of the answer to that is simply it's part of the evolutionary process whereby norms are being generated that eventually evolve into these quote-unquote binding treaties, these harder, quote-unquote harder norms. But the other way to look at that is that those are simply manifestations of what's occurring at the national level, that there is quite a bit of commitment to environmental norms that is not yet fully integrated into the international system, but that sort of makes its appearance in these international instruments, like these declarations and non-binding commitments in international treaties, you know, as sort of a manifestation of these changes in the changes in the law that have already occurred at the national level. The second one here, and I'll have these two, and then I'll open up for questions. The second one, I think, to my mind, though, is maybe the most important implication and substantively important. And that is Article 38 of the International Code of Justice, right? I assume that most people here do not have familiarity with public international law. Article 38 of the Statute of the International Code of Justice describes what the sources of international law are. The source of international law are treaties, customary international law, and general principles. Why is it significant? Article 38 simply describes what the International Court of Justice can rely on as international law, right? So part of that's obvious. Treaties are international law. Customary international law, if you're not familiar with that, customary international law is sort of the equivalent of the common law in the international context. That is, legal concepts that have evolved even though they haven't been formally written down. I mean, it's not a great analogy, but maybe if you're not familiar with international law, that hopefully helps understand what that means. But this last one, this general principles prong here is most important. General principles have traditionally been understood sort of as these background principles of the law, right? Res judicata, the idea that commitments, contractual commitments are reciprocal, for example. All those kinds of concepts actually are found virtually in every legal system in the world. And they're sort of deemed to be these general principles of how we think about the law, the idea of law and the nature of the law. And they're incorporated into the legal principles that the International Court of Justice can consider when they adjudicate disputes between nations, right? And the Article 38 here is also oftentimes seen as a general description of what international law is. So if general principles here are these kinds of background principles, how do you figure out what a sort of general principle is? Well, there are two ways, actually, that have been described in the ICJ opinions. One is you simply just think about, you know, sort of this abstract inquiry. You know, what is a sort of fundamental principle of the law. What I've just described to you, is part of the thinking that's evolved over the century. Res judicata, reciprocal obligations, all of that are well established. There are none that have been recognized with regard to the environment. And part of the reason is, this is evolved over centuries. Environmental issues in international law have really made their appearance only over the last 50 years or so. And in that sense, I think there's an evolutionary process here. Some kind of general inquiry into the nature of law has been sort of the traditional way of figuring out what is a general principle. Really very abstract, very academic in this sense, but it's also a process that some arbitral tribunals, the judges in the International Court of Justice have actually engaged in. I mean, you can read these opinions that, read like, jurisprudential treatises to some extent. But there's an alternative way, actually, that is well established as a way of determining what a general principle is. And that is simply an empirical comparative law inquiry. What you do is you simply look across the legal systems of the world and ask, what kind of principle is shared by all of these countries? And the premise is, to the extent that that is, in fact, a principle, a concept that appears in every legal system, that may very well be a general principle of law. And so this is sort of where my study sort of is relevant, in that to the extent, and the argument here is, and I will actually say that, this is not, there are, I won't get into this, but there's definitely areas where one can disagree. I mean, this is an argument here as to the significance of this. But to the extent that you find the duty to conduct an environmental impact assessment all across the world, the argument is that this is a general principle of law. I mean, to simplify, there's some abstraction issues here. And as a result, there are concrete legal implications of that. If you accept that the EIA duty is a general principle of law, it becomes part of the set of legal principles in international law that governs any dispute, found in international law. It becomes part of the set of law that the ICJ can draw on in resolving disputes. The WTO, the Law of the Sea Tribunal, and all sorts of other arbitral international tribunals. It also suggests that it is part of the law governing international organizations and could even be part of sort of background principle governing treaties. Right? I mean, that latter part here, I think, is a little bit more difficult. But there are concrete legal implications here for this. So this is sort of what the paper argues. But there's an additional sort of second level of implications here, I think. To the extent that the argument is successful, it really opens up, I think, a whole new area of research and advocacy. And that is, just as I said before, environmental law has evolved very rapidly across the world, much faster at the national level than in international treaties. And this is one of the great frustrations of international environmental lawyers, right? That you have all these treaties, but very few of those norms are binding. And so, it's a frustrating exercise to be lawyering international environmental law when there's nothing really to lawyer about. This really provides an alternative answer here, in that to the extent that you find concepts that are evolving and emerging as binding norms in a national system, the argument is that those may very well become or emerge as binding international legal principles. Of course, as they would be applicable sort of in an international setting. And I will identify one specific candidate beyond EIAs that I think has a sort of a spread across the world, and that is how to best describe it? The right to a healthy environment. Right? This is This is a right that has been incorporated into many constitutions, national constitutions. There is an issue with regard to implementation and enforcement of those. But part of the reason why I point out to it is it's really had this particular idea has really spread very rapidly across the world. And the last one here, that issue here that I'll raise here and I'll finish, is that this also represents a really, I wouldn't say radical, but really very different approach to thinking about international environmental law. Traditionally, treaties and customary international are really a top-down way approach to the creation of law. That is, government representatives negotiate norms, treaty commitments, countries sign on, become parties to them, and then they go back to their national legislatures, and the national legislatures enact law that implement it. So law and norms essentially get passed down from the very top at the international level all the way down to the national and local community level. This is a very different alternative sort of bottom-up approach in that norms are essentially being developed, I suppose, really at the national level, and by virtue of their acceptance and adoption across the world, they become part of international law. And I think this is significant, finally, really sort of from an advocate's perspective, in that it opens up an alternative approach, an alternative opportunity for shaping the future and the growth and the shape of environmental law for the future. Right. Let me leave it at that, and I'll take questions. Thanks.
As questions?
You're also stunned and impressed.
I was curious whether you think that the development of common legal norms across different nations varies from industry sector to industry sector. This question is based on my observation that in the field of land use, planning and regulation, national approaches vary enormously one from the other. And so I just was going to throw out the suggestion that when it comes to plastics manufacturing and oil and gas operations, you might see a lot of commonality among the laws of different nations because you're dealing with an international industry, which tends to work across borders. But land use, the business of land development is very local, and therefore there wouldn't be the same pressure for creating common norms. And so that just leads me to raise the question whether the nature of the regulated activity is one of the things that drives the degree to which national norms tend to converge.
Yeah. No, absolutely. I mean, I think that's a great observation. This is not, I think the argument here is not designed to suggest that everything is the same across the world, really, but rather to suggest that there is a, and I think this is really true across different fields of law, right? That a lot of the specific approaches and doctrines really are specific to the locality and to the particular jurisdiction. And and I would maybe turn it around. I mean, the starting premise that I used to have is really that all law is really local. And to me, I mean, from that perspective, really, is that it's a surprise that we see these kinds of commonalities. I think as an alternative, I would also point out, however, that environmental impact assessment is actually one of the primary methods by which many countries are engaging in land use control, actually. And so, so I don't know whether that helps. I mean, it's useful, but clearly, I would really just say that there are commonalities, based on some of those pressures, but that doesn't mean that everything is the same, clearly.
Yeah, I'm Doug Whitehead from the U.S.-Asia Partnerships for Environmental Law. I have two kind of unrelated questions. One is I was curious what you thought of the role of sort of other areas of law, like greening other areas of law. So I'm thinking particularly the financial system. So for instance, like if a company wants to apply for a loan at the World Bank or something, having environmental impact assessments as a requirement and how you see that fitting in that picture. And then the second question I had relates to the transplantation issue. I was wondering to what extent you've observed leapfrogging so to speak, in there,
Yeah.
particularly thinking about China's environmental public interest litigation system.
So on the first question, greening the financial sector. Clearly, the multilateral development banks actually have been really at the forefront, and some of those, the financing process, EIA is really part and parcel of those decision processes at this point. More generally, with international financial services, I have to confess, it's not, there are, so these international voluntary standards series, the Equator Principles, all of that has become much more important. I have not followed that as closely. The second question about leapfrogging. So I think that's a great question, actually. I mean, and this is something that I haven't really talked about here, but there really is a flip side here to what I've just suggested here. And that is not only about, quote unquote, the West, what is it, the white man's burden, the West educating the developing world. But there really are, I think, lessons for the United States to learn about how environmental law has evolved elsewhere. And I would point out really just to two things. One is a general one, which is the last time that this country, putting aside the 2015 TSCA Reform Act, the last time we've had major environmental law reform, it just came up in the discussion just the other day, was 1990, right? The 1990 Clean Air Act amendments, which drastically reshaped an important regulatory system in the U.S. 28 years since then. The modern environmental regulatory system here in the United States was created in the span of 20 years between 1970 and 1990. All the environmental statutes. And clearly what we have now is in need of reform and updating. The other one issue that I would point out is there are actually specific issues, I think, where the United States is behind and where they're really the U.S. Environmental jurisprudence could clearly benefit from what other countries are doing. On EIA, actually, just as many other countries don't only impose a process requirement, they're actually substantive mitigation requirements, for example, that many other countries impose. But one other area that I work on is environmental justice issues and private environmental law, human rights. Our environmental regulatory system is largely a public law system, great for the public interest. But if you are actually the person who's been injured by pollution, you have suffered a toxic tort, the modern environmental regulatory system really doesn't provide you with great answers. I mean, that is not, the system is not set up. And I think there's some need for, it's an area really where, our system could do a lot better.
Professor Latham, you get the last question.
Right. Welcome back.
Thank you.
So, Tseming, how do you see President Trump's approach to foreign policy, which has been summarized as America First, affecting international environmental law?
I won't curse, but I mean, it's hugely disappointing. So, I mean, there are two sides to this, right? I think that the one that, so one side is, and part of it is personal also. I was part of the Obama administration. I was involved in no, I was at the top of that state because the deep state is still there, right? But, so it's disappointing to see the dismantling of things that were the subject of a lot of negotiation and a lot of careful thought and discussions with industry, right? And starting from the Clean Power Plan to all these other things. And clearly that is not in the interest, I think, of the United States. I think American leadership is significant in international law, in the international system, especially in the international environmental, on international environmental issues. I think part of what we saw is during the pre-Obama years, really sort of real lack of engagement on climate change. So little happened. You have 8 years and all this activity Then, of course, we have sort of this retrenchment. I think, but the flip side is, and this is maybe a more optimistic sentiment, is that, one level, I think we have developed quite a bit of momentum on some of these environmental issues. A lot of the international treaty systems have been moving forward. I mean, clearly not as effectively as they could with US participation, but they are moving forward nevertheless. I think in part, for example, of all the chemicals conventions. On Paris, on climate change, my sense is, countries are moving forward. And the most important thing here to remember is the importance of the United States is not as great now as it was 20 years ago. 20 years ago, I think, when the Kyoto Protocol was negotiated and adopted, failure of the US to participate in it really, I think, did a great amount of damage to that. Nowadays, the most important countries, most obvious, right, is China. India, the developing world, is far more important at this point than the United States. Not to diminish, I think, the role of the United States, but climate change is going to be solved in the future by thinking about what the developing world is going to do. And I think there's quite a bit of momentum going forward with their participation. So that is sort of my optimistic side. On that note, thank you. Thank you.